Hello students, welcome to XII and embrace the XIV learning experience. I have started a series with respect to the Companies Act wherein I am basically discussing the various important provisions that are there in the various chapters of the Companies Act, and that is basically from the various competitive law exam point of view. I have already come up with some of the parts of this particular series, and this is the further part. In case if you have missed to watch any of those previous parts, you can go to the very description of this particular video जहाँ पे कि आपको link मिल जाएगा previous parts का, and you can watch them. In case if you have any questions or queries or you want to clarify any of your doubts, you can connect with us and we'll be helping out with your queries, and for that you can connect us through the email ID or the phone number which is displayed on the screen. Now in this particular video, I'll be moving ahead with the further chapters and the important provisions therein from the exam point of view. But before that, let me remind you over here to subscribe to the channel and press on the bell icon so that you can stay tuned and stay updated. Now moving ahead with our chapter-wise revision of the Companies Act series. So in this particular part, I'll be going ahead and discussing chapter 11 and chapter 12. That is basically dealing with the various aspects related to directors, their appointment, qualification, meetings, etc. Now, before we move ahead with the discussion with respect to these things, we are first going ahead and understanding who the directors are. In very simple, we can say कि ये वैसे individuals होते हैं जो कि take care करते हैं और they oversee the entire management and operations of the company. They are responsible for going ahead and making the important decisions, ensuring that there are compliance with the laws, regulations. They basically represent the company. So first of all, we need to understand who the directors are. So in very simple, we can say that directors are those individuals who basically oversee the entire management and operations of the company. The day-to-day operations of the company, they are basically being taken care of by the directors. And they basically typically serve on the board of directors of the company. That is, you can say, the governing body of the company. There are various provisions under the Companies Act that is basically laying down the various requirements with respect to the directors. Now, if we talk about that, companies, they are required to have board of directors. Now, this board of directors which will be there, it is required to have certain number of directors. So, in the context of public company, it is provided कि 3 directors होने चाहिए कम से कम, private में 2 and OPC में 1. क्या कोई maximum limit है with respect to the number of directors that is provided? Yes, there is a limit with respect to that, and that is maximum number is of 15. However, this number can be increased. There may be more appointments than 15 directors, but for that there is a special resolution which is required to be passed. Further, one of the directors is required to stay in India, and that particular period for which is required to stay should not be lesser than 182 days. And 182 days कब होगा? During the financial year, that has to be taken into consideration. अगर वो listed company है तो एक director वहाँ पे जो है small shareholders भी appoint करेंगे, और ये जो small shareholders है ये भी provided है under the section that who they are basically. So those who are holding shares जिनका nominal value जो है 20,000 rupees से ज्यादा नहीं है, they will be considered to be the small shareholders. Now, if we talk about the requirement with respect to the minimum number of independent directors and all. So before we move ahead with the minimum number of independent directors, we first need to understand who the independent directors are. Okay, they are very important with respect to a company. So you can say they are the non-executive directors. There are executive directors who are basically involved into the day-to-day operations management of the company, and then there are non-executive directors जहाँ पे कि independent director है. They are basically the ones who are not having any kind of material or pecuniary relationship with the company, you can say, or its management, so that the decisions are not being affected by those, or the decisions, they are independent and in the best interest of the company. They are basically playing, you can say, a very crucial role for going ahead and providing an impartial decision with respect to the company's management, ensuring transparency, accountability and all. Now, if we talk about the requirement with respect to independent directors, so it has been provided that अगर वो listed company है, then over there should be at least 1/3 of the total number of directors as independent directors. Now, if it is an unlisted public company, over there 2 are required to be an independent director, and if it is that particular case, there are certain threshold limits which have been provided. If that is is fulfilled, two persons have to be appointed as independent directors. Is there any tenure requirement with respect to their appointment and all? If we talk about that, yes, there is a requirement with respect to the tenure of the independent directors. So basically, they can serve on the board of the company up to 5 consecutive years and they are eligible for reappointment. But अगर reappointment करना है तो special resolution pass करना होगा और disclose करना होगा board report में. Further, the section is providing that they will not be holding office for more than 2 consecutive terms and be eligible for appointment after expiration of 3 years. So this first point and this third point, if we connect them and if we understand them, basically that is providing कि जो independent directors हैं वो serve करेंगे board पे company के for a maximum of 2 terms and each of these terms will be of 5 years. ठीक है, तो 2 term के लिए वो serve कर सकते हैं और एक term जो है 5 years का होगा. So up to you can say 10 years continuously they can serve. But it is further provided that after completing these 2 terms, they will be required to step down from their respective position as independent director. However, they can be considered for reappointment. So once they are not holding their respective office, they have stepped down from there, they will be required to wait for a period of 3 years. Once they are waiting for a period of 3 years before they can be reappointed as independent directors, they can go ahead with the appointment. So basically, this 3-year period you can consider as the cooling off period. Okay, so that is the waiting period, the cooling off period. Basically, that is there to ensure that the company is getting a balance of the experience and the fresh perspective on the board of the company. So that is there. Now, apart from this, if we talk about the remuneration which they will be getting, so sitting fee they will be getting or they will be getting reimbursement with respect to the expenses and all जो भी incur करेंगे वो with respect to their participation in board or other meetings, profits related to commission, etc. That all will be basically their remuneration. Now, further, the provisions are there with respect to DIN number. This is also very important from the exam point of view. So these sections are basically providing the various aspects with respect to the DIN number, like you can see section 153, 154 till 157, that is talking about the DIN number. Director's identification number, that is the unique identification number which each director is basically getting in a company. So DIN number is basically issued by the MCA, that is Ministry of Corporate Affairs. So as I mentioned, it is one of the unique numbers which is assigned to each of the directors. Now with respect to this DIN number, there has to be an application that has to be made, then there has to be an allotment, etc. If we talk about that, application for getting DIN number has to be applied or that has to be made to the central government. So obviously if the application is being made to the central government, तो allotment भी central government करेगी, but that has to be done within a period of 1 month. क्या कोई prohibition है with respect to obtaining more than one DIN number? So yes, there is a prohibition. So one director, one DIN number has to be there. And that particular DIN number is valid till the time person is a director in the companies. Now the director will be going ahead and intimating the company within a period of 1 month that he has got the DIN number. So whenever he is the director, he has to intimate the company. And in turn, the company will be going ahead and informing about the DIN number to the registrar within a period of 15 days. Now, there are certain requirements with respect to the number of directorship. So if we talk about the number of directorship, it has been provided that the total number of directorship which a person can have is 20. That will also be including alternate directorship. अब ये alternate directorship क्या है? If we talk about that, so you can say when a director he will be temporarily unavailable, okay, due to any reasons, then there can be appointment of someone else to basically act on his behalf. This other person who is being appointed to act on behalf of the director, he is known as an alternate director. So if we talk about the directorship in the public companies, that has to be 10, which will be including the private companies that are actually either holding or subsidiary of a public company. So total number of directorship a person can have is 20. That will be including the alternate directorship. But if we talk about their directorship in public companies, that can only be 10 and that will also be including the private companies, whether they are holding or subsidiary of that particular public company. Then Then there are women directors. Okay, so this was basically brought by the 2013 Act, wherein one women director that is required to be appointed if it is a listed company या फिर public company जहाँ पे threshold limit ये है जो कि specify किया गया है, and so the appointment of one of the women directors has to be made. Now if we talk about the resignation of the directors, so for the resignation the directors can go ahead and give a notice to the board. Once the board is going ahead and receiving this particular notice, the board will ensure that it is intimating to the ROC within a period of 30 days that the particular director is going ahead and resigning. That particular fact has to be placed in the director's report of the subsequent general meeting of the company, और website पे भी ये post किया जाएगा information. Now, the director who has resigned shall be liable even after her resignation from the office which occurred during his tenure. So it is not that if you are a director and you resign, you will not be held accountable for the offenses which actually occurred during your tenure. So anybody cannot go ahead and just misuse the provision with respect to resignation, that if they are involved in any offense and all and they resign and so they will be not accountable. So the Companies Act provides that no, that's not the situation. So अगर आप director हो and आप involved in any of the offenses that occurred during your tenure, then you will be held responsible even after your resignation. Now, if we talk about the removal, so the company will be going ahead and removing a director. So if there is a removal, it is basically before the tenure. So for that, an ordinary resolution has to be passed. Then the removal will be taken ahead, and special notice that will be required with respect to any resolution that is there with respect to remove a director or to appoint somebody else in place of a director who will be removed. So a special notice will also be required with respect to that. Now if we talk about chapter 12, that is meetings of the board and its powers. So we had already seen meetings of the members, okay, where we saw the AGM, EGM and all. Now this is the meetings of the board, okay, so the board can go ahead and conduct or hold its meeting and all, but there are certain requirements with respect to that. If we talk about that, section 173 is providing that first board meeting जो होगा कंपनी का, that has to be held within 30 days of incorporation. ये general rule है, यहाँ पे exception IFSC companies के लिए है that they can basically go ahead and hold that meeting within 60 days of incorporation. जो भी subsequent board meetings होंगे, public हो या private company हो, that has to be 4 in a year. और जो gap होगा with respect to these meetings, that has to be of 120 days. So gap of 120 days between two meetings has to be there. If the company is OPC, private, startup, small company, etc., then there has to be at least one meeting which will be held in each half of the calendar year, and there also it has to be ensured that a gap of 90 days is there between two meetings. Notice with respect to the meeting, that is important. Yes, it is important, and 7-day notice has to be given. Shorter notice can also be given if one of the independent director is present or he is later on ratifying him after circulation and all to the directors. हमने shareholders meetings of the members में देखा था, there is a quorum requirement. The minimum number of people who are required to present for the meeting to be valid. So यहाँ board meeting के लिए भी there is a quorum requirement. It mentions that 1/3 of the total strength or 2 directors, whichever is higher, has to be the quorum with respect to the meeting. जो भी number of interested directors हैं, 2/3 or more हैं of the total number of directors, then the other directors should not be lesser than 2. So this is the quorum requirement with respect to the meeting to be held. Then loan to the directors. This particular section is very important from the exam point of view. So basically the Companies Act provides that a company cannot go ahead and give loan to its directors and all. So you can see that a company cannot go ahead and give loan, guarantee, security, etc. to these its directors, directors of holding company, partners, relatives of directors, etc. But further, it has also provided that they can go ahead and give to a person in whom a director of a company is interested. अब ये कौन होगा? A person in whom the director of a company is interested, that has also been specified, and it has been provided कि एक company, एक private company in which the director or his relative is a director or member, body corporate है in which he is holding or controlling 25% or more of voting powers, या फिर body corporate है जहाँ पे कि MD, manager, board of directors, they are acting on his directions. So they will be considered to be the persons in whom the director of a company is interested. तो यहाँ पे it can be given, but there has to be a special resolution that has to be passed, और ये ensure करना है कि जो भी loan amount है that is basically used for the principal business activities. So basically जो section 185 है loan to directors, that is not prohibited, but there are certain restrictive provisions that are there, so that have to be taken into consideration and then it can be taken ahead. Further, the section provides that the company can go ahead and give loan to the managing director if it is as a part of their job, you can say, or as a scheme which is approved by the shareholders and all, or if the company is regularly giving out loans as a part of its business, then that can also be done. So you can see over here, a company can give loan guarantee, provide security to MD or whole-time director, as I mentioned, if it is a part of the service which is provided to all the employees and all, special resolution will be passed. Then if it is basically with respect to the ordinary course of the business of the company, or if it is with respect to the subsidiary and all. But over there also it has to be ensured that the loan amount that is being used for the principal business activities. So restrictive है, prohibitory नहीं है for going ahead and giving loan to the directors. Then we have the related party transactions. These are also very important provision. Related party transactions. तो यहाँ पे जब भी आप ये section पढ़ोगे, दो तीन चीजों को आपको ध्यान रखना है. Like what are the related party transactions? So you can see a list of these transactions which are considered as related party transactions. Then there is a term related party which has also been defined. So you have to be aware of who the related parties are, and then when you study who the related parties are, वहाँ पे एक term आएगा relative. That also you should be aware of. Now, section 188 is not saying that related party transactions are prohibitory, but there are certain restrictions, certain compliances which have to be taken care of, and then these type of transactions, they can be taken ahead. So, if we talk about the related party transaction, basically the companies, they cannot go ahead and enter into contracts or arrangements with related parties if it is with respect to the sale, purchase or supply of goods or materials, buying or selling of the property, you can say leasing of the property, etc. But there are certain conditions and limits which have been prescribed for such contracts or arrangements, okay, and then they can basically go ahead with that. Now, if we talk about that, only after the consent through board resolution in the board meeting. So, every contract or arrangement which is made by the company with the related party and all, in that case, there has to be a board resolution that has to be passed, and then that particular transaction can be taken ahead. See, the first thing is that if it is in the ordinary course of business, or if it is at arm's length, then it can be taken ahead. There is no requirement of approval, consent and all. Then the second is there is a board meeting that has to be held and board resolution has to be passed. So board's approval, you can say, that has to be taken. The board's consent has to be taken with respect to the related party transactions if it is not in the ordinary course of business and all. And third is that there has to be the ordinary resolution that has to be passed and approval has to be taken. In what situation that has to be taken? If the transaction that is basically amounting 10% or more of the turnover with respect to these transactions, or if it is amounting 10% or more of the net worth in case of this type of transaction, उस case में जो है approval has to be by way of ordinary resolution in the general meeting, and then only those type of transactions, they can be taken ahead. So basically the entire focus is to ensure transparency and fair dealing in the contracts or the arrangements which are involving related parties, and so as to prevent, you can say, the conflict of interest and protecting the company's interest also. So prohibition nahi hai, restrictions hai, exceptions hai, that have to be taken into consideration, and then related party transactions that can be taken ahead. So यहाँ पे जो पहला exception है वो क्या है कि अगर it is in the ordinary course of business, then there is no consent or approval that is required. If that is a related party transaction, so in that case the board's approval has to be taken, the consent has to be taken by way of board meeting. And if it is in the category of any of the transaction which is amounting to a certain threshold limit which has been provided in the section, then in that case ordinary resolution has to be passed in the general meeting and the consent has to be taken, और तभी वो transactions को go ahead मिलेगा. So with this we come to an end of our today's discussion with respect to this part of the series. Do remember to subscribe to the channel, stay tuned and stay updated so that you can make your preparations 50% faster with us at XII.